So you've got a design that you want to protect. This video is going to answer all your questions about how to patent a design. Be sure to watch all the way to the end because we give you some really important information about the intricacies of patenting designs because it's not always intuitive. So if you're new to the channel, my name is Dylan Adams. I am a patent attorney and author of the best-selling book, Patents Demystified, which is an insider's guide to protecting ideas and inventions used by inventors and entrepreneurs worldwide, including top universities like Harvard, Stanford, and MIT. You might also recognize me from being featured on CNBC's hit show, The Prophet with Marcus Lemonis. So in my patent practice, and as a patent attorney, I work with clients of all sizes, including Fortune 100 companies, startups, and Shark Tank companies. And this channel really helps give you the inside information, the secrets, if you will, on how I help these clients be successful. So be sure to subscribe to the channel, click that little bell icon so that you get notifications of when new great videos are coming out. So yeah, let's go ahead and jump right in to the content. So you've got an awesome design that you want to protect. Now it's important to kind of figure out what sort of designs are protectable and how they're protectable. And let's first talk about intellectual property. So designs are protectable by intellectual property. And there are four main types of intellectual property. There are trade secrets, there are copyrights, there are patents, and there are trademarks. And you know, certain type of designs are going to be protectable by most of these. So with trade secret is going to protect designs that, you know, you aren't going to be publicly disclosing things, you know, but while they're still in development, trade secret may protect those things, but that's not really why we're here. I mean, we're talking about designs. These are going to be products that you're going to be selling. These are going to be public things. So it's probably going to be more of a copyright, trademark, or patent protection that's going to be relevant. So designs, you know, things like artistic works, those can be protected by copyright. Trademarks, there can be some trademark protection for designs. If you have, you know, like a specific trade dress or say, you know, a logo, there can be designs like that can be protectable. But what we're talking about here is design patents, patenting designs of things. And there are two types of patents that are going to be relevant here, both a utility patent and a design patent. And it's a bit of a misnomer and something that gets people confused. They think, well, I want to patent a design of something, I need a design patent, which is typically honestly not the case. Usually what they want is actually a utility patent. So let me tell you about utility patents versus design patents and why most of the time a utility patent is going to be the way to go. Some of the time a design patent application is going to be the way to go. And there are some cases where you're actually going to want to file both on the same product. Okay, so here's the thing with design patents. They cover a single ornamental design of an article of manufacture. So there's a couple of important things there. One is it has to be useful articles. It's going to be, you know, anything, you know, that is utilitarian in nature. And there are some things that are kind of surprisingly, you know, fall in that category. You know, things like furniture. Furniture is very artistic, but at the same time, you know, the design of furniture, that would be something you would have to protect with a design patent. But with design patents, they are very specific to one design. If you look at a design patent or a design patent application, it is line drawings of every perspective, you know, like left, right, front, side, top, bottom, maybe perspective views. It's going to be one design. So design patents, they're good in the sense that they're pretty easy to get through. They're relatively inexpensive, but they're only protecting that one design. Okay, that's why design patents don't work a lot of times for most products because, yeah, you may have protection on that one design, but that's not what's really important. The important thing is the variation of design. It's about the functionality. That's where utility patents come in. So design patents, they cover a picture. You know, you have a picture of one specific design. Utility patents, they cover things with words. Yes, you'll have descriptions and drawings in a utility patent application, but you're not limited to one specific look. You can have different variations. There can be really broad utility patents that cover a lot of different variations, or there can be some really narrow utility patent applications that, you know, effectively have the same scope as a design application because they are so narrow and so specific that, you know, it's essentially, you know, one very specific design that's covered. But a lot of times utility patents are going to be a lot more powerful. Like I said, in addition to covering, you know, sort of the physical configuration of things, you know, in that sense, it's kind of covering a design as well. It can cover methods of using something, methods of manufacture. So utility patents have the ability to cover functionalities in addition to physical configurations of things. And they're able to do it a lot more broadly. So then why wouldn't you always file a utility application? Utility applications, it's a lot higher of a bar to get a utility patent application issued. You have to have a product that is new and non-obvious compared to everything that is out there. With a design, usually it's pretty easy. As long as there's no one exact design that's exactly what you have, you're going to be able to get your design patent application through, and usually pretty quickly. Whereas with a utility application, there's going to be more of a negotiation. You're going to be trying to get the broadest scope possible. It's not just a binary thing where you have a patent or you don't. With utility patents, it's, do you have a broad patent that covers a lot of variations, or is it really narrow and specific to, only one very narrow design, which is not a good thing. So that's why there's a negotiation. There's going to be rejections, and there's going to be a lot more prior art that's going to be relevant to a broad variety of things. And that's why the process is going to be a lot longer, equals a lot more expensive, and it's a lot more difficult. If you have a design that is fairly generic and it's something where it would be obvious to do in view of other things, or if general designs or functionalities of that thing are out there, your application may be rejected and you may not be able to overcome those rejections. So that's the only downside with utility patent applications. So the takeaway here is that designs can be covered by both design applications and by utility applications. It really depends on the product. Some products you kind of want to do both because there's important functionalities that need to be patented with a utility application, but then there's also important design aspects that need to be patented. My suggestion is talk to a patent attorney about this, because it's really a nuanced thing. It's going to vary from product to product as to what type of application is applicable, and whether you want to file both, and you want to also consider the cost as well. Sometimes we'll file both a utility application and a design application because we know, well, the design is going to be more narrow, but it's guaranteed to go through, and that's going to be beneficial. You'll be able to say somebody is patented. And then maybe the utility application is a long shot, or maybe the utility application is protecting a method of using the product or some underlying functionalities that just the physical look of something isn't going to cover. But again, talk to your patent attorney. It's very product by product, and not necessarily an intuitive thing. So designs definitely protectable by patents. Yeah, I hope you enjoyed the video. Be sure to like and subscribe. Give me a comment as well. What do you think about protecting designs? Have you ever tried to protect a design? Do you have any patents or patent applications? Do you have any questions? Does it did this make sense? Do you just disagree with anything? Let me know down in the comments below. I'd love to hear from you. And also, if you have any questions about patents or startups, if you have any suggestions for additional videos, I would love to hear those as well. So hit subscribe, hit the little bell icon so you get notifications, and like the video. YouTube algorithm loves it when people do that, and that would really help support the channel. Thank you so much for watching, really appreciate it, and we'll see you again in the next video.